All right, well, good morning, everybody. Thank you very much for your service in this trial. I'm glad we were able to wrap it up a little bit quicker. Got it now?
Yeah, I think it's on. Tap it.
Testing, testing.
I can hear you, so that sort of tells me it's on. Go ahead.
Or I speak loudly, yes. So again, thank you very much for your diligence in paying attention to this trial and the facts. I know the testimony wasn't always the easiest. First of all, it could be emotional at times, but second of all, I'll be the first one to stand up here and tell you we have 4 different people seeing 4 different things at 4 different times, right? That's human life, right? We've all experienced this. This isn't a Hollywood movie script where they're gonna come in and perfectly match because they're seeing different things, they're viewing things from different viewpoints, right? And let's not forget the violent attack that they had just witnessed and the trauma and the shock that their brains were undergoing at the time they're witnessing this and then trying to recall it. And of course, there's been some passage of time, it's been about a year. So all of that leads to this situation we have here where we have different versions of events. But the question is, are they credible? Did you believe these 4 people who came in and told you about what they remembered and how this played out to the best of their ability, right? And same with the videos. You know, I surely wish we had a better quality video outside on the sidewalk, but we don't. So we presented to you the best that we have, and we presented a couple different versions that the crime lab was able to enhance. Whether you find those useful or not is entirely up to you to decide. But we're not relying on just one witness or one video, right? It's the whole entire series of events and the recollection of the witnesses. Ask you to piece together, can you clearly make a determination here as to what happened, okay? So I'm very grateful that you were patient and paid attention, because you're gonna have your work cut out for you. I'm not gonna stand here and say this is an easy case, this is an open and shut case, and you know, should you take you 10 minutes to deliberate? I would never say that. And certainly on a record like this, we have a lot of different viewpoints and a lot of different information to consider. So I appreciate that you're willing to do that work, and we're grateful for your service here. I want to start out by just talking a little bit about the events that we have been discussing here for the last 2 days. And I'm going to start where we ended, actually, with our case, and that is the words of Kevin Sehmer, right? The question still remains why any of this happened. We still have never found an answer to that. No one was able to tell you why Mr. Sehmer was so upset about the choice of Josh Davies to tattoo his body. What difference does it make to Kevin Sehmer? We have no idea. But seemingly that was the underlying cause of this entire incident, is that immediately upon seeing Joshua Davies, he took exception to his appearance. He told Detective Hoffa in his interview that he didn't like him from the start. And I think that's readily apparent from the video inside Tabby's wine bar, that immediately upon meeting Josh, he's making derogatory comments to him. You're a sinner, you've marked up God's work, you're going to hell. That's not a friendly interaction between 2 people who have just met out on a Saturday night trying to enjoy a really very common activity that we all participate in. Hey, it's summer, finally, it's June 17th, let's get outside, let's go to a band, let's have a couple beers, let's enjoy our friends, right? And to walk into that bar trying to meet up with Laura and meet Mr. Sehmer for the first time, what the heck happened? Well, he ran into Kevin Sehmer. That's what the heck happened to Josh. So Kevin Sehmer gives an interview to Detective Hoffa. I'm going to play a little clip of it for you. I'm not going to play the whole thing. This is, I'm sorry, could you turn on? So this clip that I'm going to play right now is from State's Exhibit 24.
Kind of lost my cool, and I say I lost my cool. I just, what did you say? And then I went outside. The girls tried to, say,
Yeah.
they're drunk, and I'm like, well, and I swear to you on my dad's grave and on my kid's life, I went outside and his friend and this guy had stools
Okay.
in their hands, and
So the guy and his friend had stools?
yeah, they're up in the air like this,
Okay.
and I said, what did you say? And then, now, now you're gonna hit me with a stool. I'm not saying this, but I'm
Right,
thinking,
right.
oh, I'm gonna get knocked in the neck, with a stool.
Okay.
And 2 stools. So, but so the one friend, he tried to hit me with a stool first, and I don't know really what happened, but all I did was block it, and that was it. And I didn't touch him. I didn't say anything to him. Nothing.
Okay.
Then the other guy, the husband, he comes in. He winds up and he's gonna not, and I don't know what the hell happened with me, if I had some almost, it was like psychic power or something. I just held my hand there and I just pushed him with the stool in his hand, and I just pushed him away.
Okay.
He fell over onto the ground, and then I left.
Okay.
So let's unpack that a little bit. There are multiple lies or falsehoods stated by Mr. Sehmer in that statement when he's being questioned by Detective Hoffa. It's not in this clip, but remember he started out by claiming both guys were drunk. They were pretty intoxicated, he said. Well, the record's quite clear. Brian Richardson had 1 beer the whole night. You can see Brian in the video. He is not impaired. He's not intoxicated. But Mr. Sehmer wants to make it seem that way because that's to his benefit, right? I got attacked by 2 drunk guys. So he embellishes, he lies, he misdirects, whatever word you want to use. He's not being truthful with Detective Hoffa. Then he says, I walk outside and both guys have a stool above their head. 2 stools. He doubles down on it. He goes back to that later. 2 stools I'm confronted with. That never happened, ladies and gentlemen. Not one witness, not one piece of videotape shows Brian Richardson with a stool in his hand ever. But he's got to say that, right? Because that makes it better for him. Well, I had no choice. I had to go after these guys. 2 of them came after me, and they both had stools. So he's got to make that up. Then he says, Brian tried to hit me. Brian never tried to hit Mr. Sehmer. Nobody saw that. That's nowhere in any video. Then he says, the husband, Josh, he came in and he really winds up. Those are his exact words. He really winds up. And I was able to just push him away. And he fell down and I left. Nobody, not one witness on that sidewalk saw Josh making a motion like this. Not one. It's not in the video anywhere. Now you could say, well, maybe it happened back closer to the Tabby's door and it's not on the video. John Laporte would have seen it. Brian Richardson would have seen it. Jen Davies would have seen it. His own wife came here, courageously told you those events that night. And she told you, yeah, I did see Josh with the stool and he had it up here. Never did she describe a swinging motion. Nobody did. It didn't happen. He's got to tell these stories so that it looks good for him. Well, I had no choice, I had to punch him, or push him, as he would say. Nobody has Josh swinging a stool. In fact, I'm gonna play another excerpt for you. My desktop here. No. Thank you. I just lost my cursor here. You can? There it is. Okay, thank you. This is Exhibit 8. This is the video from Hometown Pharmacy. This is the original version, not anything changed by the crime lab. Close out the PowerPoint. I just can't see it here. Okay. See, we do test these things and I still have user error.
Can you go to settings? It's not.
There you go.
Okay. Sorry, I just need to duplicate my screen.
It's
now.
fine.
Okay. All right. I apologize, folks. So as I said, this is Exhibit 8. This is the original clip from Hometown Pharmacy, not enhanced in any way.
Right now, we have a,
Yeah, when I start, it'll,
okay, I
Thank
was
you.
worried about the traffic cone.
thank you. I started it at the beginning. And I pause it at 12 seconds. Through the door of Hometown Pharmacy, you can now see Josh Davies standing there. I'm going to click it ahead one frame, 13 seconds. Watch his right arm as I click through these frames. His right arm is down at his side right here in this frame. 14 seconds, still down by his side. 15 seconds, still down by his side. Now he makes a step to the right with his feet. And there you can see at 15 seconds, a motion like this with his right arm from his hip area up, right? He is not doing this. He is not doing this. His arm is down near his waist at all times, right before the blow gets delivered by Kevin Sehmer. I'll continue playing. I had paused it at 12, 13, 14, and 15. I'm starting again at 15. There he goes. And there's the follow through from Kevin Sehmer. 100% inconsistent with what he told Detective Hoffa. He claims he's the guy making this motion. I just went like this and blocked the stool. He did not. That's a follow through, folks, from a right hook. He stepped through it. You see his body turn. That is a solid punch to Joshua Davies' head. That's what that is. He did not make the motion Josh Davies made of that. He stepped over. You see his body physically turn. That's the force of the punch. Nobody saw Josh Davies swinging a stool ever. It did not happen. Mr. Sehmer, in his interview with Detective Hoffa, is trying to make himself look good. He's trying to justify his actions. He's telling her misinformation, falsehoods, because he wants to say, 2 guys started swinging stools at me, and I had no choice but to hit one of them. Now, another thing that was suggested during the opening statement of Attorney Shiro was that, well, there really wasn't a battery at all. We think Josh just tripped on the stool and fell on his own. Nowhere in the video do you see that. No eyewitness described that. They were all asked. Jen was asked, Brian was asked, John was asked. Did you see Kevin trip over anything? No, I did not. I saw Kevin Sehmer punch him in the head, and then he dropped to the ground like a house of cards. That's what I saw. He didn't trip. There's no evidence he tripped over the stool. None whatsoever. And in fact, that is directly contradicted by the testimony of our medical examiner, Dr. Bidzicki. I've only known the woman 30 years. Bidzicki. Remember how she described the level of force, the acceleration that would have had to have occurred in order for Josh to have the injuries that he did. That is not consistent with a trip, she said, because there would not have been enough acceleration from a simple trip or a stumble. I asked her, how much force do you think would have to be involved for injuries like this to be obtained? And she said, quite a significant amount of force. Quite significant. Remember, she described the hemorrhaging in the brain that was so deep. She said it's actually pretty unusual to see that level of injury that deep in the brain because of the sheer force. Remember, she was using that term, the velocity, the shearing force when that head hit the ground. Sadly, because Josh was unconscious and couldn't brace himself in any way, fell down. John Laporte described in detail, and I'm sorry because I know this sounds really cold, but he saw Josh's head bounce off the sidewalk. And that's exactly what Dr. B said. Remember how she described the injuries in the front of the brain, from the brain hitting the skull in the front? Her testimony absolutely matches the witness statements. And the event as we know it unfolded is that Kevin Sehmer forcefully, violently smashed Josh Davies in the head and caused his injury and ultimately his death. Interestingly, not even Kevin Sehmer told Detective Hoffa that Josh tripped on the stool, so that was new information in the trial. Even Mr. Sehmer never suggested that. He admitted that he pushed Mr. Davies forcefully, and that's what caused him to fall. I'm now going to play a clip from Exhibit 26, in which he expressly...
Period. So I'm going like this, trying to, and I think he's going like this and trying to hit me, and as he's doing that, I luckily got a good, with the open hand, I got a good grip of the, and I didn't grip it, but I mean, I got a good spot on the stool where I just, if you wanna use the word violently, that's kinda unfair, but I would say, yes, I pushed him, down with one open hand, and he immediately went down to the ground, and I didn't say nothing to anybody else. I turned around and I walked away. That was it.
So not even Kevin Sehmer claims this was just a trip or a stumble because Josh was so inebriated, he had lost all of his motor skills. Remember that? By the defense, they brought in Dr. Henson to try and tell you that he had lost his gross motor skills, his fine motor skills, and he was so intoxicated that he couldn't even defend himself. Attorney Zillaby asked him that. Well, if he's this intoxicated, then he wouldn't have an ability to defend himself from a sudden attack, right? And Dr. Henson admitted that. There's no evidence, and you can see the Tabby's video, that Josh Davies was unable to comprehend what was going on around him, that he was stumbling, that his balance was impaired, that he could not function properly, right? Hey, I get it, folks. A .24, yeah, I'm not here to tell you he was stone sober. I'm just here to say it did not have the impact on him that you may expect. You just hear a number. You don't know anything about it. You don't know how much he had to eat. You don't know what his tolerance is. So look at the video with your own two eyes and tell me, was he grossly impaired by his level of intoxication? If so, where is it in the video? In fact, what we see in the video that I just played for you, number 8, is him walking backwards very adequately, right? Backpedaling 5, 6 steps, whatever it is. Is that somebody who is grossly impaired? He's not grossly impaired. He's got a .24 BAC. He is not grossly impaired. You cannot reach that conclusion based on this record. Nobody said it. Nobody. The people that are with him that night, and the video speaks for itself. Absolutely not. This incident is not attributed to Josh's level of intoxication. It's attributed to the actions of Kevin Sehmer. Had Kevin Sehmer not punched him in the head and knocked him out and caused him to fall to the ground and hit his head, he would not be dead. It's just that simple. That's why Kevin Sehmer is charged with felony murder, because he engaged in a felony, that is aggravated battery. He punched Josh in the head. Aggravated battery. And when Josh fell to the ground and hit his head, that's what led to his death. It's his actions, his conduct that caused Josh's death. No other conclusion can be reached on this record. I have an opportunity to speak to you again in rebuttal because it's my burden of proof. And in fact, as Mr. Sehmer has claimed self-defense, I have to overcome that and prove to you this case was not self-defense. So I'm going to reserve some of my comments for my rebuttal closing. There's other things I want to talk to you about, but I think they will be more helpful to you in the context of understanding the defense position that this was self-defense. Thank you.
The state has spent a lot of time trying to make this homicide case about an argument where my client was acting boorishly and inappropriate. I think I told you in the beginning I didn't think you would find that his behavior was okay inside Tabby's. It wasn't. But this case isn't about bad behavior inside this bar. It's not. Mr. Davies was never injured inside Tabby's. there are really two issues. They're complicated factually, but there's really two issues. First, not complicated. Did Mr. Sehmer batter, punch Mr. Davies? That's one issue. If you determine that my client didn't batter him, didn't punch him, then that's it. Then it's not guilty. As simple as that. I think that's what happened here, and I think that's what the evidence shows. But let's just kind of break it down so that you can understand, because it's a little complicated. The second issue is, well, if we thought he battered Mr. Davies, was he acting in self-defense? That is, was he doing whatever he did because he was being assaulted by Mr. Davies? I indicated initially, that is in the opening statement, that this was an argument that had already ended. Now, I'm not asking, nor should I ask, that you not consider the fact that my client had been acting badly in the bar. I mean, that's obviously evidence in the case. It's, however, as I again would state, that's not where Mr. Davies was hurt. So they had, that is, Mr. Sehmer and the two women were talking, okay? I doubt they particularly liked Mr. Sehmer, although they did both stay there, and they were talking. It wasn't a long time. At some point, my client, gives a hug to Ms. Burke, but whatever, and they were standing together, the two women. And if Mr. Davies doesn't come in the bar and start screaming to Mr. Sehmer and to his wife, "Are you still talking that blah, blah, blah?" There's no event. And there isn't. So while it doesn't mean that what my client had done previously doesn't matter, but it is like, well, okay, the facts of this case are that it really had kind of stopped. It didn't make him not a boor in his behavior, but it was over. And then Mr. Davies came back in. I think, based upon the evidence, is that he didn't like the fact that his wife was still talking to him. I mean, I kind of get it. It makes kind of sense. He's probably thinking, why are you talking to that jerk? I mean, he was just rude to me. So I get that. I mean, I do. I'm not critical of Mr. Davies. I'm not. I mean, I get it. He was mad at that point, and probably more mad at his wife. But he was mad. And then when my client hears this, my client then goes out of the bar. And the two women try to stop him. It doesn't quite work. He gets upset. And they try to get him out. I mean, they try to get him to not go out because he had been angry already once. Okay? But then what happens? Okay? Now, you're going to see, this is what Ms. Burke wrote that night about what happened. And you remember, she was, she didn't go outside like Ms. Davies did. She says, "From inside, I saw through the window that Josh had a chair raised above his head." Now, this is not Mr. Sehmer saying this. Okay? Let's be clear about this. This is not Mr. Sehmer's statement. This is Ms. Burke's statement, a longtime friend of Ms. Davies and a friend of Josh's. She is the one who says that night he had a chair raised above his head to hit Kevin as he approached. That's her statement, not Mr. Sehmer's. I think I overheard someone say, he has a chair, or he's going to hit him with the chair. Again, this is Ms. Davies and Josh's friend. That's what she saw that night. not Mr. Sehmer. She saw it that night. Now, Ms. Davies, she says that her husband picked up a chair or a stool to defend himself. And she's, not very happy with Mr. Sehmer at this point. And she says, the man who I know as Kevin ran after him screaming at my husband about God and tattoos. My husband defended himself and picked up a chair or a stool to defend himself from this crazy person who went after him for no reason. Okay. Well, what does that mean? Well, it is that night, and I do understand that she was upset, okay? This was, in fact, traumatic for her. Her husband was now in a hospital while they're doing, that is, medical professionals are doing things to help him. She has an opportunity to write this statement out. Now, and I understand that people, when they're upset, maybe they're not as clear as we'd like. But what's disturbing is that what she should have been upset about, if her current story is true, that is, if she believed, based upon what she saw, that Mr. Sehmer punched her husband, causing him to go to the ground. Is it reasonable? Is it in our life experience that you would exclude the single most important fact of this incident? This thing that has put your husband in the hospital, that you would not include what it is that she now says is the reason he was in that hospital, the punch. Now, with all due respect to Mrs. Davies, this is a difficult circumstance. I get that. But when I asked her about why she didn't include it, she seemed to suggest that, well, I thought we were all going home. I think that's kind of what she said. That's really not unreasonable. Not only is it not reasonable, it's kind of ridiculous. It is impossible to believe that that's the excuse that you didn't write. He punched my husband. Had she really seen him, my client, punch her husband and has him go to the ground, it would be the single most important thing she wanted to make certain that law enforcement knew. He punched him, but she didn't. She went part of the way and said that he picked up a stool to defend himself, which is like what Ms. Burke said. The two women there both said the same thing. He picked up this stool. And I think Ms. Davies says he had it up here by his head. Ms. Burke said it over his head. I don't know that it really matters, okay? But if we take, for example, Ms. Davies' statement, it's here by, kind of above his shoulders. And she also, having acknowledged that he did that, she also in her statement doesn't say that he chucked, I think was her word, I hope that's right, but something like he chucked the stool at Mr. Sehmer. Now again, just as it is difficult to understand or find credible that you would do this, you would write this statement and not include that he, Mr. Sehmer, punched him. It's also difficult to understand how you're actually writing about the fact that he had this stool to defend himself and not say, well, how did he do that? It is kind of an interesting absence, okay? Now we have I'm not including that he was punched, even though I'd seen it supposedly. But I'm not going to include what he did with the stool or chair. Everybody thinks it's a stool, a metal stool. So instead, she waits till the trial, not in her statement, to say, well, he just chucked it. Well, you would have said that night. Yeah, he had a chair, but he just threw it on the ground, or threw it towards him, but didn't do anything. I mean, she says to defend himself, well, okay, how? Now, it doesn't matter that she doesn't have all the details, but the two important details are, one, say that your husband was punched by my client, and two, and what he did with the stool that he was defending himself with. So those two witnesses, the state seems to suggest, tell the same story, and they kind of do. The story, though, is that Mr. Davies had a stool and used it to defend himself. And in fact, somebody even screamed, he's going to hit him. I mean, that's what they said that night. That's what they said that night. It's a different story now, but I get that. But the government has to prove this case. And I'm sorry, it's a bit odd to suggest, well, I know this is really complicated. And I mean, they're all telling different stories. As if in our system, you can convict somebody of a crime, a serious crime, even though, well, nobody really knows what happened. They don't really know because they all saw things and they're all different things, and yeah, that's okay. Well, is it? Is it okay that they can't tell a story that makes any sense? Some of it is just simply not sensible. But that's what the state is asking us. Now, the other thing that's a little odd is that Ms. Davies, again, I'm not trying to be mean to her, she says that she was actually right with my client. I mean, with her husband. I mean, she was right next to him. Now, you're going to see these videos because I'm going to play them because they really kind of matter. What you're not going to see is Jennifer Davies anywhere near there. I mean, nowhere near her husband. I mean, she's just not there. Now, one of the witnesses says, well, she never came out, but she's not there, okay? Which is a little odd because given what you're going to see and already have seen in these videos, you're going to see that Josh does kind of launch himself. I mean, if you look at it slowly, you can see he literally is launching himself. And he then, something happens and he goes down. Now, the state can say, yeah, there's the follow-through of a punch that we can't actually see. I don't know. I don't know how much counsel knows about boxing, but it's not like that. So she was right there. Presumably, if she were right there, you remember how we see he just goes down. She'd be right there. And there are reasons that we would think, one, she wasn't there, and two, if she was, we'd have seen her. But she wasn't. So the videos, and we're going to play them, and I'm not going to play just one, and I'm not going to play the first one. We're going to use the enhanced slowed one, okay? Because I want to show you some stuff, okay? And I think it would be fair to say that any of us who have been dealing with this, and now you folks, have to deal with these videos, and they are hard, okay? They're hard. They're hard because you're looking at various different things. You're trying to look and see where maybe somebody's legs are, where somebody's hands are, where their head is, where they are, where they're moving. But I just want to show you these videos because you really need to see these. And with all due respect, the prosecutors claim that, this shows it all. Well, it does, but it doesn't show the battery that you're saying. That isn't what we're going to see. You can pretend you're seeing it, but you're not. So let's just take a look at it, if I may, okay? And I apologize, you're probably sick of seeing these, but they are important, okay? And without seeing them, it's hard to judge this. All right. Now this is the enhanced, Okay, they made it better, make it easier for us to see. And then we're gonna play that, and then I'm gonna play it where it's slowed, okay? So you get to see the same thing, but you're gonna see it first fast, real time, and then halftime, okay? So if you could play that.
Jeff, I'm sorry to interrupt, but can you please tell us what exhibit numbers you're displaying?
What number?
This is Exhibit 12.
Exhibit 12.
Thank you.
Thank you. Now, what we just saw was a couple of things. And I don't expect you to see everything you've seen, but we've seen a couple things. We clearly see Josh moving backwards, right? I mean, there's no question about that. And then he does seem to move a little bit to his right. And then we see him kind of launch himself. Can you back this, tap this? See how it looks like he's going up, and it does appear, and I can't tell you I'm sure, okay, I'm not. It does appear that both his legs seem to leave the ground. And then the next thing is, shortly after that, he is falling kind of to his right and down. Now, I'm gonna have her play this, the next one, which is, what number?
Exhibit 13.
Number 13. This is the half speed. Thank you. Okay, so again, it's hard because even slowed, it's still a little complicated, and obviously looking through these windows we know isn't perfect. I mean, it's just not perfect. So, but again, it does appear that, well, one thing that's utterly clear is that this isn't Josh standing there and getting punched. This is Josh moving. I'm using the word launching because his legs seem to get off the ground. Now, I'm going to tell you why I think he did that in a moment, but that's what the videos show, okay? Now, of all the witnesses that had some information, all but Mr. Richardson says that Josh had a stool at some point. Obviously, both Mrs. Davies and Ms. Berg are very clear that, yeah, he had it. They hear people yelling that he's got a chair. Mr. Richardson said, no, he never had a chair. Now, he has had some issues in the past, and you are able and can consider that incredibility. But it doesn't, you don't get to say, well, you know, I still want you to consider his testimony. You believe him even though what he's saying is different than everybody else. We can't do that. We can't ask you to plug this into make you computers and say, all right, what does all this mean? Well, the state has to prove this case. It's not just like, oh, just figure it out, but it's all okay. Well, it's not okay if you're trying to prove that my client committed this crime, because it's not what they're saying he did. Now, Mr. Laporte originally said that possibly Joshua had a stool or a chair, I think a stool, but later he said, no, that didn't happen. It's a little odd because you would expect him even to say, well, I wasn't sure, but now I'm sure he didn't have it. But in any event, his testimony is kind of not helpful to anybody. quite frankly, because he puts this whole event a half a block away. And if that were true, there wouldn't be any activity over here. If you'd be way to the left of this, I mean, it just didn't happen. I don't know why he recalls things the way he does and why he claims he saw what he saw. But it's so out of the range of anybody else's version of what happened. And it is utterly refuted by this video. Whatever Josh and Mr. Sehmer are doing, it's not a half a block the other way. I mean, it's right there. So I don't know what we can say about his testimony other than it doesn't support the state's burden of proof in establishing guilt. Now, do you remember when Mr. Armstrong talked about absolute difference? It's a little, let's look at absolute difference. What he said, and this is the dark one, the two dark videos, okay? What he says that objects that are darker, that are stationary, and they get lighter if they're in motion, okay? It's weird, I don't completely understand it, but that's what he said it does. So I want to show you these for a minute. There's two, okay? And I'm going to show them to you. They're in different speeds. There's a regular speed and the partial speed, okay?
This
So-
is Exhibit 14.
Thank you.
Go ahead, keep playing. Okay, now, one thing that is pretty clear already, just even in full speed, is that this is where Mrs. Sehmer said she was, and there's nobody there. And if she had been there, she would have had to have been moving around here. She would have been very clearly a moving, sounds rude, a moving object, a moving person, okay? She's not there. That's relevant because it's kind of an odd thing to be so wrong about when she was there. She just wasn't there. Right, now I gotta clear this. All right. Now we're gonna play it slower. And what number is this, please?
This is Exhibit 15.
All right, I want you to tap. No, go back. All right, there.
Starting from 4 seconds.
4 seconds. Stop. Back it up just a bit. I know.
I'll do it.
Back it up. Tap, tap, tap. Stop.
Mhm.
This taps, please. Stop. I need you to tap this so that it stops there, please, okay? Don't run it at their speed,
Mhm.
okay?
Okay. Would you like me to slow it down?
Yes,
Give me more. Okay.
but you gotta back it up now. Stop. This. See that? That's it's now lighter because it's moving. Something has just moved, quite frankly, right at his feet. And there's something else that we see, which is this. Okay? You see how there's light there? We went from it being kind of dark, I mean, and it's all moving, but that is a moving object. That's why it looks lighter. That is the stool. Can I be 100% certain? I'm not going to tell you that. All I know is that Mr. Armstrong told us that's how this works. That if something is moving, it is lighter than something that is just stationary. And we've now seen two things. We saw this thing, we've seen that thing kind of come down. It looks kind of towards Josh's feet. And up here is something, now this lighter thing is here. Now, go ahead and just play it this way then. I think I have to clear this. I'll go slow. Thank you. We have now seen two things from absolute difference. That's what they call it, so that's what it is. And what it is showing us, two very significant facts. This is the government's evidence. This is the government's expert brought this in. And what we've now seen are two really important facts that I think are somewhat irrefutable. One, something has come at his feet, and two, as he's lunging, as I've called it, we see movement. We see this lighter, whatever they call it, which is something that happens when something's in motion. And what's in motion here is not, as counsel says, him raising his hand. No, it's him with the stool in the position, quite frankly, that his wife had put in his hands earlier. Remember when he said he was like this? And what Ms. Burke says, he had it over his head. Now, of course, he can move, but the notion when she said it was like at this is exactly what we just saw. That's what we saw. Thank you. So, the videos do show that, one, Mr. Davies lunged at him. Two, that Mr. Davies had something in his hand, and it's the stool. Now, I'm not going to claim that I know everything about this absolute difference, but I know what he told me. And what he told me makes it clear that what my client said is accurate. Now, I understand that the state claims, well, this is all Mr. Sehmer's fault. Well, he did get in an argument with him. He did act like kind of a jerk. I get that. And then Mr. Davies comes back in and starts, yells at him and reignites this thing. I wish my client hadn't left, but it's not a crime to leave the bar and yell at somebody who just called you a name. But it's not a crime to do that either, okay? Now, I have to differ with the prosecutor's belief that the medical examiner and Dr. Henson both essentially say, well, it doesn't matter, he was, he really wasn't drunk. I can tell you, I think without fear of contradiction, that no prosecutor in the state of Wisconsin has ever told a jury that a person with a .24 blood alcohol level was not impaired. That has never happened, probably in the history of Wisconsin jurisprudence. Nobody would say such a thing. It's laughable. It's, quite frankly, ridiculous, and it's just a bit offensive, considering my client's on trial. That, oh, well, 2-4. Come on. I mean, he's got a tolerance. We saw him. Well, yeah, we did see him, but it's a video, and 2, we don't really hear him say anything other than yelling some profanity. I don't know. I can't say exactly how it affects him, but I know nobody in law enforcement in this state or this country thinks that somebody with that much alcohol is not impaired and is not with less faculties. Now, why does this matter? It's not to make him seem like a bad guy. I don't care if anybody gets drunk and they're not driving. What difference does it make? But in this case, his effort to try to hit my client with the stool is made more complicated because when Mr. Sehmer blocks it forcefully, he doesn't have the ability to right the ship that he's just started down the path. He's up, his feet are kind of off the ground, he's trying to hit somebody, and that person forcefully resists that. Now, we did talk a little bit about the fact that everybody tolerates things differently, okay, and that's true. But there's a certain level of which, and I think Dr. Henson made it pretty clear that, well, at some point, everybody's impaired. Now, the other thing that's interesting is the medical examiner, she had an opportunity to see all the records, had the opportunity to do the autopsy. What she never said, never provided any testimony about, was that there was any injury to the side of Josh's face. Now, the state is arguing that there was this unbelievably hard smash to his face. But not one bit of medical testimony or evidence suggested that Josh had any injuries, not any bruising, nothing regarding this, not a bit. So you can say, well, it was really it must have been a hard punch because he hit his head so hard. Well, she then suggested and agreed that, well, of course, if somebody is, pushing and somebody pushes back hard, the law of momentum, the law of motion, okay? You can throw yourself down if you're doing this and somebody's going this backwards, and it appears, Mr. Sehmer being quite a bit heavier, would be in a position to exert far more force than the lighter Joshua. Now, it is pretty hard to argue that my client hit Mr. Davies so hard that he did all this damage, and despite a plethora of medical people, medical personnel, nurses, doctors, and the medical examiner had all these records, and nowhere in there does she say, or did she find, that there was some evidence of any injury to his face. Now, given the degree of force that they're claiming my client exerted on his face, not on a stool that he was holding, that's hard to understand. Now, in Mr. Sehmer's interview, he wasn't utterly candid about everything. I mean, I think, but what the state didn't remind you of is that when he initially said there were two people with the stool, that later in that in the interview, he said, yeah, you're right. I acknowledge it. It was just Josh. It wasn't two people. So when he first said it, all right, he said it. I don't know why he said it. It may have been he was trying to protect himself. It may have been that given the circumstance of these two people, I don't know, I can't speculate. But you can't act as if he didn't say that, correct it. I mean, he did. He said, no, I agree. It was just Josh, it wasn't both of them with the stool or with chairs. So, I don't know, other than the fact that what he said is utterly consistent with absolute difference, I don't know what else he could say. Now, as I indicated earlier, there's really two issues. One, did he commit a battery? Nobody, I don't think, is arguing that a person, whether they claim you provoked it or not, that you're allowed, once you provoke something, you're allowed to get hit in the face with a stool and you're supposed to just take it. You can't put your hand up. You provoked this, so you're gonna get what's coming to you. That's not the law, okay? Now, the issue of provocation is interesting. You know, it's a judgment you'll have to make, okay? I mean, whether the initial argument where my client wasn't behaving badly, I think is enough to say, well, that's provocation, he doesn't get self-defense. I think most people would hate to think that if I misbehave, 10 minutes later, if somebody, calls me a name and I go want to talk to them about it, even if I am moving fast, that, well, too bad, you're gonna get anything you have. If they wanna, hit you with a baseball bat, too bad. You were a jerk, so you get to hit in the head. I mean, but is it really a battery? I mean, is that reasonable? First of all, is it a battery to block a punch? Is it a battery to stop a stool that's being swung at your head? According to the state, that's not a battery. Or that is a battery, I guess. I don't know. I mean, because they have to prove that he intended to harm him. That's what a battery is. You caused harm and you intended to. Is it intending to cause harm when somebody tries to hit you with a stool and you block it? That's not intending to harm. That's just stopping something. Even if you go like this. Now, the second issue is, again, so if you say, well, that's not a battery, then the case is over. And did they prove that it was a battery? And remember, as the state acknowledged, they have to disprove self-defense. It's not like I have to prove self-defense. Once this has become an issue, which it clearly is in this case, okay, the state has to prove beyond a reasonable doubt that he wasn't acting in self-defense. And I think it's hard to say if somebody hits you with a stool, you can't block it. So, but it's their burden of proof. But I'd like to talk to you about the burden of proof for a minute. The judge is going to give you the instruction, okay? There's a couple important facts. One, the defendant is entitled to every reasonable doubt, if there's one, okay? That is there a reasonable doubt as to what happened? Now, I alluded to this earlier. If the state's witnesses cannot tell the same story, it doesn't mean you can't convict somebody, but it's hard to say, well, I don't have a reasonable doubt about what happened here when I don't get same stories, or where stories change, where locations change. He starts with the presumption of innocence and it remains. And it only stops if after you reviewed everything, you conclude that, well, no, he did this, beyond a reasonable doubt. Now, one of the parts of the jury instruction says that if you can reconcile the evidence on any reasonable hypothesis consistent with his innocence, you must find him not guilty. You're not given a choice. If you say, well, we've considered this evidence, and there is evidence here that seems to suggest, and it's reasonable, that he didn't punch him, that all he did was block this, that's a reasonable hypothesis. Now, is it the only hypothesis? No, but if it's a reasonable hypothesis, and we know that absolute difference makes it a reasonable hypothesis, it's the actual truth, that Josh was swinging something. Now, the issue of this tripping, I have indicated, and I believe, that there are really three principal things that caused this. One is that he had left his feet and he was swinging a stool, which was blocked. Smaller force met larger force pushed it away, and he fell. The second is that he was intoxicated, grossly so. Now, again, it's not a judgment on him, but it does make it harder for him to do what he's trying to do physically, and it caused him to go down. And lastly, that there does appear, I don't know if you want to call it a trip or what you want to call it, but absolute zero showed that something came right at his feet, just as about the time he's about to, launch. I don't know if that's a trip or if that's just another factor, but those are factors that caused him, I think, in part to go down. But the principle is he's trying to swing a stool, and my client blocks it, and in his intoxicated state, he fell. One of the things that the jury instruction says is that we should consider these things, like what is a reasonable doubt, okay? And it's complicated, but, I think they do a pretty good job of explaining it. One of the ways they explain it, because they try to do it in a number of ways, one of the ways is this a kind of doubt that would give you pause or hesitation in acting in the affairs of life, okay? And, lawyers both on the state or on the defense or civil litigation, they all kind of can talk about this a bit, not in civil litigation, but, and they say, what are the kinds of things that we consider that are important in life? And would you not pause before you made such a decision? I've heard examples of well, if your child needed surgery and the judge and the doctors are saying, well, there's this and there's that, you could do this process, you could do this, or maybe you don't do that. And some people say, well, that's something that's an important affair of life. And would this cause you to say, well, I'm going to pause and hesitate before I make that decision? I don't know if that's completely fair, but it does kind of illustrate how important this is. I mean, it really is important. And that is, before I say guilty, before we say guilty, I need not to have those doubts. I can look, I will examine it all critically, but at the end of the day, you can't say that I'm not in a position where I'm like, whoa, I'm really pausing on this. I don't know how you get there. How do we get to, he did this? And I don't think the state did that. I don't think the state can do that. And when you hear the state keep saying, well, there's this problem, that problem, and it's, it's a long time ago, and, I'm sorry, my client's trial is today. And I understand it happened a year ago. But they have to prove beyond a reasonable doubt that he did this. And we don't get to just say, he was a jerkin' tabbies, and don't worry that they can't, keep their stories consistent with the state's theory. You have to say no. There's both a reasonable hypothesis consistent with his innocence, and there are many, many reasons to doubt. And I think there are many reasons to doubt, and I'd ask that you find him not guilty. Thank you.
Now, he would have you believe that at this point, he gets outside and two guys are out there with stools, right? That's his original version to Detective Hoffa. I walk outside and there's two guys, all armed with stools, all revved up and ready to go. Well, then, Mr. Sehmer, wouldn't you just turn around and walk back into the bar where you just came from? For safety? Why would you go out there in the first place? Why even go out there in the first place? But if you did, and you walked out there and there's two guys with stools over their head, wouldn't you just turn around and go back inside if you're not looking for a fight? Kevin Sehmer's looking for a fight. Kevin Sehmer thinks he's a tough guy. He thinks Josh is a little girl. This is provocation, folks. Provocation from start to finish. Charging out that door. after Josh. You saw the hometown video. Josh is backing up, trying to get away from this raging bull. And he keeps going. He's afraid. He's afraid for his safety. Why keep going, Mr. Sehmer? Turn around and go back in the bar. Absolutely no explanation for his behavior other than he wanted to hurt Josh. He didn't like him from the start. He didn't like his tattoos. And he's going to be the one to finish this, right? He's not going out the back door with Laura, not returning to his friends. In fact, he ran. He goes up to Josh, punches him in the head, and runs. Leaves his friend behind at the band and gets the heck out of there. And when the cops go to his house at 5 a.m. to talk to him, doesn't come to the door. How drunk was Kevin Sehmer? Well, be nice to know. If he hadn't run, police could have talked to him, gauged his level of impairment, maybe asked him to take a breath test. Who knows? We know Laura Burke said he was drinking all night. Every time she saw him, he had a drink in his hand, and he was drinking vodka. Cops knock on the door at 5 a.m. He doesn't answer, so can't view him then. It's not till about 1 o'clock in the afternoon that he finally shows up at the police department and they can get eyes on him. Well, that's 12, 14 hours later. Kevin Sehmer's the one who's acting like he's impaired. He's belligerent, he's difficult, he's argumentative, and he's right. No matter what anybody says, he's going to get the last word. He's right. This was not self-defense by Kevin Sehmer by any stretch. This is a man looking for trouble. I don't know why. It's absurd. Laura Burke said he was perfectly fine at the band. When I met him out at Beer Snobs, he was a nice guy. We got along. All of a sudden, what switched in his brain, I don't know. But I do know he attacked Josh Davies outside that bar for no reason whatsoever. I know that he punched him in the head, causing him to fall down with such force that it damaged the inner core of his brain. That's not tripping over a stool. At the end of the day, ladies and gentlemen, you don't have to figure out why he did it. I don't have to prove a motive. I can't. I can't prove a motive to you. What was that button?
Oh, it is on duplicate. Oh, you're in your PowerPoint, you can go ahead. Okay. Just put it just-
This is the last picture they took, Jen Davies said. There they are at the street party. Man lost his life over what? Don't know. But I do know Kevin Sehmer is to blame for it. Kevin Sehmer is responsible for his actions that night. Kevin Sehmer is responsible for Josh's death. There's no question from Brian, who was there, Jen, who was there, and John, who was there, Kevin Sehmer punched him in the head and caused significant, great bodily harm to him, and ultimately death. That's an aggravated battery, ladies and gentlemen. And the fact that death resulted makes it felony murder. Asking you to return a verdict of guilty. Thank you.